In this video, we'll be dealing with reference, review, and revision. Even though they sound same, they are different in their senses. Reference is given under section 113. So whenever the term reference pops up, should directly direct it to the High Court, because it can only be before the High Court the reference can be done. And the matter is pending before the lower court. Matter has not been disposed, it is pending. That is one of the important things to remember. It involves a question, that is with regard to validity of an act, ordinance, or regulation. And this is the keyword here. The reference can be done for checking the validity of the act, ordinance, or regulation. And such question of validity is very important to the extent that the court cannot dispose the suit before deciding such question. So when this is the situation, then reference can be done to the High Court. If the lower court itself thinks that it is a valid law, it is a valid regulation, then in such case there is no need to send any reference to the High Court. The reference is only available for non-appealable cases, that is, where appeal remedy has been provided, the person shall not ask for reference. And Order 46 lays down conditions with regard to reference, and reference can be done either by suo motu by the court itself, the subordinate court itself, or an application can be made by the party. The reference can be made on the question of law or laws having usage, like it is a usage but it has a force of law in any suit, appeal, or execution. So it could be in any stage, like it could be on suit, appeal, or execution. Reference can be made with regard to question of law or usage. So while making a reference, the subordinate court may refer with the following particulars, like it can draw a statement of fact as to what is the fact in the case, and it can it can state the points in doubt, like I'm doubtful of this point, it can state as such in the reference, and it can express its own opinion as well. The lower court can also express its own opinion. So reference has a effect of stay of proceedings. So whenever reference has been made, it'll stay the proceeding in the lower court, and but it may not always be the case. It can either stay proceeding or it can pass order or decree. So the lower court may pass order or decree, but it will make a condition, it will put a condition that this order that is passed by the lower court will be subjected to the opinion rendered by the high court in the reference. So when the decree has been passed by the lower court, it should be read along with the opinion given by the high court. Whatever the high court says, uh, it is as same as the decree. So high court, as it deems fit, hears the reference and can decide upon points. And after, if the lower court has passed the decree, then the points that has been made by the high court will prevail, and it may transmit to the lower court sometimes. Review is given under section 114. So the review is like looking again. And review is done before the same court, right, that has dismissed the matter itself. So any aggrieved person, upon appealable order or decree that is not appealable, appeal is there, it is appealable order or decree, but appeal is not preferred, like parties are not opting for an appeal. In such case, aggrieved person can go for review. So it is a general rule that when the judgment has been passed, becomes a public document. It becomes functus officio, which means the court will not have any control over such judgments. and the courts does not have control over such matters, and the exception for this particular general rule is review. Even after disposal of a particular suit, the courts can entertain review petition. So review can be done on the following grounds: whereas new fact or evidence has been discovered by the appellant, and despite due diligence, it would have not been found or known to have been produced before the a court that has dismissed the suit. And such new fact or evidence must be very relevant, right? And there is an apparent error on the face of record itself, and any other sufficient reason. So these reasons are not exhaustive. The review cannot be entertained on the grounds that law has been modified. Oh, so if any amendment has been made and later the law dimensions have been changed, so under such grounds, a review cannot be filed. And due to any patent error, failure to interpret the complicated law on part of the court, it may entertain for review, and the court which has dismissed the suit has disregarded any existing judicial proceedings. So in such cases, reviews can be entertained. And the court fails to consider material issue or evidence. So there is a relevant issue that has to be decided, and there are relevant evidences that are ought to be taken. In such case, if the court fails to do so, review is entertained. There is a condition that there should be no review on review itself, right? A review has been dismissed, and you cannot file another review right upon such review itself. The court may also is not restricted with this 114 review section. It may have inherent powers to entertain reviews under section 151 to review its wrong orders. And then comes the revision. So revision can be done by the high courts upon the any case that is decided by the subordinate court. So review is like revision is like again hearing the matter and by the superior court, so that it can overrule the decision that has been provided by the subordinate. So any case has been decided by the subordinate court, and there lies no appeal. Appeal does not lie upon such decree or order given by a subordinate court, and the law does not vest jurisdiction and fail to act in exercise of jurisdiction under any law, or jurisdiction acted illegally or material irregularity. So these three are the grounds for which revision can be made. That is, uh, the court does not have any jurisdiction but gives out any decree. In such case, the court has jurisdiction but it has failed to exercise such jurisdiction, and court had illegally acted upon the jurisdiction with material irregularity. So these are the grounds upon which we can file a revision. And after hearing all these grounds, the High Court may pass any order that it deem fit. So revision is not an automatic stay, right, of the subordinate court decree. And discretion is not a matter of right. I mean, revision is not a matter of right. It is a discretionary power that is vested with the higher courts. And according to Article 131 of Limitation Act, a review must be filed within 90 days, right? And these are about review, revision, and reference. Thank you.